This meeting is being recorded.
All right. Good afternoon, ladies and gentlemen. Thank you very much for joining us today for this third webinar in the ISDS webinar series organized by Association Arbitry. Today, we are lucky enough to have Dr. Nikos Lavranos, who will address a very important topic, which is the proposal for the establishment of the Multilateral Investment Court. That is one of the most prominent proposals in the process of ISDS reform, which aims not only to introduce something new, but it aims also to replace ISDS as we know it. It is one of the most systematic proposals to date, and there are many interesting nuances to explore. We were lucky enough last week also to hear from Ms. Samira Sulejmanovic, who has participated actively as a representative of the government of Bosnia and Herzegovina in the process of ISDS reform. And we have heard from her what are the impressions and what are the states facing in this regard when it comes to these elaborations. But in short, just to give some more context about the MIC, the idea is to have a standing body, which would be a court with standing judges. The parties would no longer be able to appoint the arbitrator, so we will have no more ad hoc arbitration as we have it today. It would perhaps also have a preponderant appellate mechanism that will have the second instance for the review of the decisions. And in any case, it will be a total swift change from the ISDS mechanisms that we have today. Now, although this proposal is still being framed, it still hasn't received its final contours, it is very pertinent at this point to think about the implications of this body, not only at the European level, but also potentially at the international level. And in any case, aspiring countries such as Bosnia and Herzegovina, who would like to join the EU at some point, should keep a very keen eye on this mechanism and what it may entail in the future. So this is only a brief introduction. Our prominent guest today will definitely give us some better insights, but please allow me before we engage in the discussion, just to briefly introduce you to our guest, Dr. Nikos Lavranos. He is an expert in investment law and arbitration who has expertise in advising, litigating, negotiating, and drafting legislation and providing expert witness reports. He is the owner of NL Investment Consulting, and he is also the Secretary General of the European Federation for Investment Law and Arbitration. He is a prominent speaker and writer and author, and also provides extensive consulting services. And in addition to investment law and arbitration, he also covers the World Trade Organization law, EU law, and the interaction between public international law, European law, and national law. Again, it's a very brief snapshot. I would kindly encourage you to research and look up Mr. Nikos Lavranos online, where you will find an extensive list of his publication and various very important projects in which he is involved. So with all that, welcome. It is wonderful to have you with us today.
Thank you very much. It's a great honor, well, I'm looking forward to a very nice conversation.
Thank you very much. So let's ease into the conversation because, as we know, the topic is very complex and multifaceted. But at this point, it might be a good idea just to introduce our participants and the audience today into the origins of the idea behind the MIC. For those who are casually observing this process, it might seem like a new and radical idea, but there are some historical elements of it. So how long has it been on the table in the EU, and where is it coming from?
Yes. Well, it is coming from the EU, that is for sure. And originally, this started somewhere in 2013 when there were, for some of you, you might recall when there were the so-called TTIP negotiations, the negotiations for a large trade investment agreement between the EU and the US. Which would include the classic ISDS provisions, investor to state arbitration, as we know them in the BIDs. However, for various reasons we cannot enter into, there was a political backlash, there was a general public backlash, so at a certain moment the European Commission, pressured also by the European Parliament, decided we don't want to endanger the signature of the TTIP or the ratification of TTIP or the conclusion of the negotiations because of this ISDS. And since suddenly, although a lot of people still don't know what it means really, investor to state arbitration, what does it entail and what is the difference with, for instance, domestic arbitration or domestic litigation. In any event, the European Commission, pressured by a couple of member states, interestingly enough, by member states of the EU that were usually traditional supporters of ISDS, such as Germany, such as the Netherlands, asked the Commission to come up with something different. And the EU, you should recall, at the end of 2009, when the Lisbon Treaty entered into force, the EU obtained exclusive competence for foreign direct investment, which included to some extent also ISDS and BIDs, not exclusively, as the European Court later clarified, but in any event. So at the time in 2012, the European Commission didn't have any experience really about investment law, but they did have experience, and they do have experience in trade law, and they do have an experience with the WTO appellate body system. And what happened is that at a certain moment, to save those negotiations, and in parallel, we, and I'm speaking as also a former Dutch negotiator at that time, we also had in parallel the negotiations of the CETA, which is the Canada-EU agreement, and also the EU-Singapore agreement. And both of them originally included the traditional investor-to-state arbitration system. Now, the EU then said, okay, we need something different. What do we know? We know the WTO system. And that's when they came up with what you rightly explained, a two-tiered system of a first instance and a second instance, which would very much look like the WTO appellate body with permanent members and with the possibility to review, in this case, in law and in fact, the awards. So that was the original idea. And as you may recall, indeed, while TTIP, because of former President Trump, was put in the fridge, CETA and all the other agreements the EU signed recently with Singapore, Vietnam, does include what is called the investor court system, which is a bilateral kind of multilateral investment court. So again, a two-tiered system with permanent judges selected solely by the contracting parties, by the states. So no party autonomy, no influence anymore by the investor or the state in that sense to select for an individual case the arbitrators, but it would be a court-like system, a kind of a combination between what we have with the European Court of Justice and the WTO system, right? So that was implemented at the bilateral level with Canada, Singapore, and Vietnam. That was easy, although I must stress, and that's very important, that none of those agreements with regard to the investment arbitration part has yet been ratified by the member states, because they need to be ratified by the member states, because even at the domestic level, many member states, including again Germany and the Netherlands, but also France, Austria, at the domestic level, the parliaments refuse to accept even the new system, right? So there is still some problem here. But nonetheless, the problem that, and then I'm coming to the answer, but I want to give the context. The problem was that, of course, as you know, the member states alone have concluded somewhere about 1,500 bids, extra EU bids. That's about half of the 3,000 something worldwide bids. So if the EU would have to bilaterally negotiate with every single country to include this new system, it would take forever. So the Commission, the European Commission, changed gears and thought we need a one-stop shop solution. And then they came up with the UNCITRAL, where we had the same experience already with the UNCITRAL transparency rules, which were concluded in 2013, 2014. And even though the EU is not even a formal member, formal member, but only an observer. They managed, together with Canada and some other countries, to create this working group and to task this working group with what they call looking at ISDS reforms. And that started in 2017. And there, essentially, because we have two groups, you can say, in the group, namely one group that fully supports the EU, which is the EU and the member states, and Canada and some other countries. But there's also another group that is led by particular Japan, Russia, Chile, US to some extent, and some Asian countries, Singapore, which consider these reforms too radical and also question a lot of technical, practical issues like who's going to pay for it, for instance, how does it really going to work, etc., etc. So in order to accommodate those two groups, it was decided that the working group would first look at, if you like, low-hanging reforms, low-hanging fruit, and these structural reforms. Low-hanging fruit was, for instance, the code of conduct for arbitrators, which has essentially been agreed upon. There will be something about a third-party funders, etc., etc. But the systemic one is now that we are talking about, and that is the idea about the multilateral investment court. So it has, to cut a long story short, it has the origin in the EU, and it's a reaction of the backlash in 2012 when it started with TTIP. And that's where we are now. And in the UNCITRAL, obviously, we have 100+ states from all over the world. And I don't know, 30, 40 NGOs and other observers, including EFILA. That's why I'm watching this very closely.
Mm-hmm. And that's a very fascinating history of something that seems very new, but obviously has very deep roots and very important reasons behind it. Like you said, it's more of a matter of practicality and matter of achieving goals of the EU sooner than later through these international platforms. And over the past few weeks when we were discussing these topics with other guests, this question came up a lot because there's an obvious dichotomy between the priorities of developing states and also those who are there openly to discuss different options, and those of the EU who came with a specific agenda, and they're obviously trying to accelerate the process moving forward. But I would just like to stay on this issue a few more moments with you, since you brought up these new free trade agreements that the EU has concluded with Singapore and with Canada and also with Vietnam. The point that you brought up, I don't know if everybody captured it, but basically you are saying that the EU already is testing these models of mini courts in these treaties that would be independent of any ISDS and any party autonomy in this sense. And you are telling us that they have not been ratified yet, mostly because of these chapters, because of this model. So do you have any other insights about what are the tensions that are preventing the member states from actually adopting it? And what does this say about the chances of the MIC?
Yes, I mean, when you look at the countries, especially with regard to Canada and Singapore, let's put it this way. The general argument is that, very simply, is why should foreign investors receive a particular treatment for being able to go into international arbitration, whereas they can go to domestic courts like any other company, right? And in particular with countries like Canada and Singapore, where we trust each other's courts, there should be no ISDS or no ICS or no international arbitration at all. No special regime, or as some call it, special rights that should be given. Obviously, you can question that because, for instance, in countries like Poland and Hungary, to name but a few, but there are, I think, also countries like Romania and Bulgaria, and even Greece and Italy, you could question whether the courts function properly and whether for investors actually international arbitration as an alternative is needed. But this is this kind of general backlash against giving what is described as giving multinational special rights. That's not anymore kind of like en vogue. And that's simply also because of the financial crisis that we had, that politicians are not going to give any special rights. So this is the main reason for that. The second reason, I think, is that, and this is in parallel starting also in the 2010s, that these Western states, like France, like Germany, and the Netherlands, over the past years, for the first time, did receive cases. That was never perceived, right? When we signed, we meaning the Western countries, when we signed bids, it was always the one-way direction that our investors would go into the Wild West or the Wild East or Wild South, and they would be harmed, and those courts could not be trusted in those countries, and therefore you needed arbitration. What has happened, as I said, for instance, also in Spain, where you have dozens of renewable energy cases, but similarly also Netherlands got one or two, Germany with the Vattenfall case about shutting down nuclear power stations, which we, funnily enough, might need very desperately now, but this is a different discussion. There is a clear feeling that bids, as somebody wrote in a nice article, that bids do bite, also for us. So it was never realized, right? It was always the intention to protect exporting investors from capital exporting countries that go into this wilderness. And now suddenly we are at the receiving end of cases. So I think that is one of the reasons, and in general, that I think you can say there is a, at least in some countries, a feeling of more protectionism, more nationalism, more national champions that we need, also vis-a-vis China, for instance, or the US, the big tech companies. So there is this general trend also to shut a bit down the borders and this free market thinking that we had in the 90s, for instance, in the 1990s.
Yes, and it seems to be a shifting world in many ways. You have policies changing. You have, foreign policies and internal policies. Obviously, the world is a much different place now than in the 1960s, when most of these bilateral treaties were concluded just promising investors the whole world and inviting them to invest and bring their capital to these countries. But now we have this situation where, especially in the EU, many countries are turning to more progressive policies, especially those that are greener, and they can also anticipate more claims coming from investors saying, you are failing my expectations. We are at a loss because of your progressive policies. So many substantive, but also, jurisprudence related issues might be affecting the situation right now. But turning now more to the functions and the contours of the MIC from what we know today, it'll be very interesting to hear, just in brief, what it is about, what it should look like, and also what is the perceived benefit of having this body at the international level. So we have discussed what the EU has intended, but what about internationally? What are they promoting as the benefits of the MIC?
Well, the first one is that they say that you would create kind of, as you rightly said at the beginning, you would create one body, one central body that would over time replace all these ad hoc arbitral tribunals, and that would create a more consistent jurisprudence. There is this perception, which I question to some extent, but there is this perception that arbitral jurisprudence is not consistent enough and needs a central body. So that's number one. The second is, as I said, to do away with the party autonomy, which I should add bites also the states. Because when you have whatever it is, 15 judges or 21 judges, but you have 150 or more countries, your national judge might not be there to defend your case, so to speak, right? So you have a Bosnia-Herzegovina case, but it might be a German judge and a Greek judge and an American judge, right? Who has none of them has any feeling about what's going on in Bosnia and Herzegovina, for instance, right? And you have no influence on this. So this is an important aspect. You take away party autonomy because they say we don't want those arbitrators who are also acting as counsel and in different other forms, which is called the double hatting. We don't want this because there are too many conflicts of interest. We want independent full-time judges that ensure independence and consistency. So that is the number one reason. The second reason is that they say it's also going to be cheaper, right? We know that arbitration costs on average, really on average, about $8 million and takes on average 4 years, but the numbers truly are really higher, both in terms of time and money. But in any event, so the idea is when you have, as in the WTO, specific deadlines of, let's say, 9 months, 12 months at the first instance, another 3 or 6 months at the second instance, you could finalize a case, in theory at least, in 2 years, and you wouldn't have to pay any very expensive arbitrators. Although, obviously, as I said in the very beginning, this court has to be financed, and the ICJ or the ITLOS, the Law of the Sea court, are very expensive. And so that's another matter. But the thing is, of course, with regard to the cheap price, you still have to pay your own lawyers. And that is the 80% of the costs that you incur in any event. So that's a different discussion, but that's the idea, that you would have independent jurisprudence and judges. And also there is this idea that, if you like, those public law and publicly elected judges would also be more taking into account the interests of the states, the public law interest. That is the hope, at least, right? So the idea is that, and that brings me to my critique to this thing, is that it could end up in a pro-state biased court, right? Because obviously when the states, and we know what a election race, the selection of ICJ judges always create, where not the best candidates are selected, not necessarily, states will naturally select persons which they consider to be leaning towards this public law interest, right? And not necessarily who are considered a more investor-friendly person. And that could mean that at the end of the day, you have a pro-state biased court, which then might not at all be used by the investors. So you might create something that actually might receive very little cases, but still has to be financed. So there is something to consider. On the other hand, there are also arguments also by the EU put forward. They say, well, look at the European Court of Human Rights. They are also publicly elected by the states, and they hand down judgments every day against the states, right? But to be fair, they usually don't hand down awards or judgments in the millions or in the trillions. So there is a little difference here, I think. So that's, I think, the main purpose. So the main purpose is that to address the concerns that many states have, rightly or wrongly, about the current system, and to replace it with a standing public international law court that would eventually, but this is a very long process, eventually, excuse me, replace all the arbitral tribunals that might be created on the basis of those 3,000 bids. And mind you, when you have players like Russia, US, Japan not on board, and we don't really know about China, and I come to that in a minute, about China, you might question whether you want this when the major economies are not part of this, right? And that maybe, if you allow me, that maybe brings us to the point, because this two-tiered mixed system is, if you like, the maximum option that the EU has put on the table. The second best option that is also discussed is to start off only with an appeal body, with an appeal tribunal, right? And then also to let every state elect whether or not to join, and with regard to which bids this appellate body would have jurisdiction. So in other words, you would leave, as an interim solution, you would leave the ad hoc tribunals as a first instance, as it is now, and only for, if you like, control questions and for review issues in terms of an appeal, you would have only an appeal body. So that would look very much like the WTO system. That is kind of an interim solution, which could be quicker implemented and might be cheaper. So the EU is aware that the maximum solution they are putting on the table might not be appealing enough for sufficient number of members of the working group. So they are offering a second best interim option, which later on may be developed into this full-blown two-tiered court system. So there are, if you like, a couple of options below which is normal, of course, in the negotiations, that are on the table as well. And that is, sorry, just to finish, and that seems to me be also favored by, if you like, China and the countries around China. I don't have the feeling that China is going for the full option, but I think they are, to what they have said so far, they would be okay with this interim option.
Mm-hmm. Yeah, and I think that is one of the main concerns that you were just outlining, the reasoning behind the MIC and its purpose. So to combat all of these perceived flaws in the ISDS system as we have it, but what they're moving towards is replacing the perceived bias towards investors with an actual bias towards states, meaning let's just make a mechanism that will make it more likely for states to be able to protect their right to regulate their public interest. Let's take this out of the hands, reduce the discretion place and area for the investors and these arbitrators who might go one way or the other. And interestingly, you have mentioned the European Court of Human Rights and all of these different bodies that they mentioned. These are very different in nature and in purpose. So if we're talking about deciding on the human rights, of course, judges will mostly come to the same conclusions. If you have fundamental rights, the reasoning for protecting them are unique and equal basically around the world. But in terms of investment cases, it's a much more colorful mosaic of complicated relationships that might need to be dealt with. So you touched upon the positions of different big countries and their reaction to this proposal of the MIC. So could you comment then generally on the positioning of this proposal in the Working Group 3, and what have you perceived in the discussions, whether they're in writing or just comments on the sessions? How do states openly comment on this issue?
Well, I mean, we just started actually just very recently because the way it works now, and that is also borne out by the frustration by the EU and its member states in the working group, because in its view it's going all too slow, is that rather than just talking on a very high level, what they are doing is, and it helps, of course, that the chair is Canadian. That's an important point to mention here. It helps that the Secretariat of Multilateral, although formally independent, is drafting. So what we've seen lately is rather, I don't know whether they are drafting completely independent or whether the EU in the background and other states are helping the Secretariat. I leave this open, but the point is they're putting drafts on the table, draft articles, right? And unsurprisingly, they very much look like what we see in CETA. And that is now kind of like where the direction of the discussion is going. So it's not anymore, at least not now, because all states essentially, except for the EU, are saying we have not yet made our mind. So whatever we say is subject to the caveat that we will later on decide what we want, right? So the discussions are always under this caveat, but by putting drafts, concrete drafts on the table, you see that the discussion has become more focused, less politicized, less political, more legalized. And so we start now really discussing articles by articles. And of course, the point is that in order to have a meaningful participation in this discussion, you must be an expert. You must understand not only what is written in the text, but also read between the lines. You must understand the context that I also try to give here to understand what is the aim, what is the history, why they're putting this particular draft on the table. So for countries, and I think that applies also to Bosnia and Herzegovina, but also particularly for African countries, Asian countries, Latin American countries, it is particularly difficult to work on that basis because they are expected, because at a certain moment at the end of a 1 week session, the chair is going to ask, okay, is there any agreement or disagreement? And if none of the countries are raising their fingers, it is actually adopted, right? So that is one of the things. You must be always participating, and not only in the formal sessions, but they are, and I cannot even participate in all those so-called informal sessions. And because of Corona, we also got many webinars being sometimes announced a week before, and of course they always say, well, yeah, it's just informal exchanging of views, but we all know that there is where the magic happens, right? So I think that is really important to understand that you need to have experts in the room being able to assess exactly and to actually raise your finger. I mean, and that's something that I think, for instance, for Bosnia and Herzegovina and other candidate countries is really very important, because for now the EU is actually speaking in the name of the member states, right? And whatever the EU says, the member states simply raise their finger and say, we support whatever the EU says. That's the only thing they say. So once Bosnia and Herzegovina becomes a member of the EU, that is what you have to do. You have no choice anymore, right? And I think that is something that you really need to realize when you join the EU. You essentially submit also to all the plans and all the views of the European Commission, essentially. And there's very, very little room that you have. And the thing is, of course, that your interests may not be necessarily the same as the interests of the Netherlands or Finland or Spain or whatever, right? So that is a bit the thing, you never know really what the European Commission, which interests the European Commission is actually defending. France is a very active player, Germany as well, and that's about it. So that is something really to realize. So the dynamics in the room and the power balance, or I should say the power imbalance, and the knowledge discrepancies is very, 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 very important and determining the outcome of this process. But for now, we are at least formally speaking, only at the beginning of looking at the at the articles that have been suggested. Um, but I think at the end of the day, it will come in one way or another, right?
Yes. I mean, that's a whole different area of discussion, and we can have a full session just about the different kinds of steps that aspiring EU member states can take now in preparation for joining this investment protection policy framework that is waiting for them on the other side, even though at this point it might be undefined fully. But still, there's a possibility that tomorrow they're going to have to raise their hand and accept these things as they are. It's funny that you mentioned, priorities in the policy area, because years ago when Croatia was joining the EU, they got instructions and support from the EU to conclude bilateral investment treaties to frame their investment policies like that. And now when Bosnia and other countries are considering it, we are at the precipice of the whole abandonment of the ISDS process, as we know. So that wasn't too long ago. It's not, centuries ago. We hope that the situation will stay stable, at least for what we know right now, so we can prepare properly. But before we address some interesting questions in the chat, I just want to also kind of solicit your comments on the concrete steps the EU is taking now to start implementing different investment protection policies. So having concluded the agreement on the termination of all the intra-EU BITs, so we know ISDS is contrary to EU law as we know it, so they had to terminate them. Between this and the establishment of the MIC in any form, what is the EU doing now? What can investors do right now if they want to protect their rights in the EU?
Well, the short answer is leave the EU. That is the bad message, and I'm not sure that is what we need. No, I mean you're right. I mean there are different layers, so to speak. Indeed, the intra-EU, for better or worse, intra-EU bids, sorry, they have been terminated. Clear. There are some issues remaining with regard to pending cases. There are still some issues with regard to awards that have already been paid out that are arguably state aid that need to be paid back. So there will be a couple. I actually just wrote also a blog post about the Mikula case. You can find it on Practical Arbitration blog. So that is cleared. The EU mentioned some time ago that they would adopt something of an EU investment regulation or something that would kind of like set out the existing rights that investors have intra-EU with regard to the four freedoms and access to domestic courts, etc., etc. So, but I don't expect much of that. Now, the more interesting I wouldn't like to use the word battle zone, but it is a battle, unfortunately, is the ECT, the Energy Charter Treaty. That is the one that through the European Court of Justice recent judgments, it became clear in Constroy's, the famous judgment, that also arbitration in the ECT context is incompatible with EU law. And mind you, this was a case, I would like to stress that it was a case against Moldova by an Ukrainian company, nothing to do with the EU law. The only thing was that the seat of arbitration was Paris. So it was actually an extra ECT case, but it doesn't matter. The European Court doesn't make those distinctions. So the question now is, and I think it's very likely that also arbitration will be considered incompatible for the EU member states. And maybe also because also of the Spanish cases, the numerous cases and other cases, they might be taken out completely. But there is this ECT modernization process and it's very intransparent. I hear nothing, so we don't know. So this is one area. The other area is, of course, that, and that is very interesting, that actually the European Commission has changed gears and has excluded or doesn't even put investment protection on the table for new agreements. So it's not on the table with Australia and New Zealand free trade agreements. It's nowhere. It was not included in the Japan free trade agreement because Japan didn't wanted it. It is not included in the EU-China investment agreement. So what happened, because I come back to that in the beginning, that's why the historic element is important, because of the resistance at the domestic level of the member states in the ratification process, the Commission is saying, we don't want to be hold up by the member states. We want our trade agreements. And if you member states also want an investment protection part, you make sure that you ratify it whenever you ratify it, right? So we go actually back to the pre-Lisbon area where the EU always had exclusive competence for the trade part, right? And the Commission dropped the whole investment protection part and actually left it to the member states, whatever they want to do it. So that's an interesting thing. And finally, just to add, and then we can go to the questions, but to come back to my other point about the protectionism, stuff like that, what you do see, one of the areas I think we really have to watch is the screening of foreign investment regulation. Been very important, and that can have a huge impact on foreign investments because they could be blocked for political reasons, for protectionism reasons, rather than for actual security reasons, right? And that is something I think that worries me, that the investment policy is really re-politicizing and is taken away from any kind of like economic, rational, legal arguments. And I think once you put this in the free hands of politicians and the media and the NGOs, it can become very irrational. And I think that is what we are seeing. So this is what the EU is essentially doing. So not concluding any more CETA type of agreements, and essentially also, and that is a final point, because we have also the grandfather regulation, where we grandfather existing bids of the member states, that over time, because the Commission has the power, it will review those bids and ask member states to include the new elements that it wants to see. So there is, if you like, a harmonization through the back door of those existing bids. But this is more of a hidden process that is taking place. So there's a lot going on in this regard. But for now, at least the European Commission is really trying to get as many concrete results out of the working group. But again, just to finalize, for instance, the code of conduct was supposed to be done deal a couple of weeks ago, but it wasn't. So it has been shifted for another year, right? So actually there are so far no concrete, even low-hanging fruit results that we see. So and that may make a lot of people angry and frustrated. And also ask the question, why should we invest manpower and money in this project when it takes so long?
Yes, and also why invest manpower and money into a project that also already has an established and determined goal? And if we're just working towards that goal, then what's the point of the discussion in the beginning? And I found a very great point that you mentioned. It seems like the discussion of the reform has lost touch with the practical side and the day-to-day purpose of ISDS and what it was supposed to do. So now we have high-level policy discussions, we have human rights implications, you have interest groups coming in saying investors are evil, arbitrators are evil, or states, depending on the perspective, but you're losing the point of why this framework was built and that it was supposed to foster and enhance the foreign investments in different parts of the world. A recent study has shown, just generally when we're talking about the perspective of the investors. So what do they think about the dispute prevention and dispute resolution and ISDS generally? And their view was, if possible, they would prefer to avoid all of that and to go amicable settlement. And this brings me to the question that we have in the chat. So do we need a court or arbitration per se? And should there be more investment in the mediation, for example, as a mechanism? Or as Melike mentioned in her question, what about mandatory mediation? Is that an option for ISDS?
Well, I mean, it is already part also of CETA and the other new agreements, almost formulated as mandatory pre-procedure before being allowed to go to arbitration. It's not entirely clear, but if you read it, it looks like that. We have the so-called Singapore Convention a couple of years ago that essentially enables mediation settlement agreements to be turned into binding judgments, because that is, of course, the main issue, how to ensure that you can enforce a mediated settlement against a party that doesn't do its part. And I think that is simply, I think, the main problem here is let's put it this way. I mean, there are essentially, if you allow me to, there are essentially two situations. You have the situation where you have a disgruntled investor who feels badly treated, and just wants to leave the country and wants to get compensated, right? Here, I don't think that mediation works. I think that's clear, because mediation means that at the end of the day, you walk through the same door and cooperate again, right? You put the situation behind you. And that you can only do in disputes where you have an investor that actually wants to stay in the country, that actually has a long-term interest and also has the trust in the government, in the persons that actually caused, in his view, the problem, is actually willing and able to correct the problem and to continue. Because exactly what you said, at the end of the day, any businessman, any company wants to make money and not to spend it on lawyers or on mediators or whatever, or arbitrators, right? That's the purpose, to make money, to create wealth, and to pay taxes, hopefully. So I think mediation has its place and will get a bigger place, but it will be for a limited particular type of these kind of investors, these kind of disputes, maybe also for small and medium-sized enterprises, for smaller disputes, let's say in the range of 5 to 10 million of investments or damages claimed. So these kind of lower end disputes where there is a chance that you can come out of this as friends again, that is what mediation, I think, can avoid a lot of those high costs that I mentioned, right? But not for all. There's a whole lot, and we will probably talk about this in another occasion. But I mean, there are a lot of also questions like, what is the power of civil servants or government representatives signing such a settlement? Because there's often this kind of perception that, well, this might be collusion, might be corruption. Why suddenly, when, everybody hated this investor, the very same government is suddenly making a deal, right? Is there some money paid in the back? So there is this question as well. There's also the question of transparency, because usually mediated settlements are not published. But the public might want to see, when taxpayers' money is involved, might want to see the deal, and maybe rightly so. So there are a lot of very difficult issues that still need to be sorted out. But mediation is absolutely a hot thing, but needs to be developed. It also requires particular experts who come from the ISDS field. I think that's very important. I think you cannot just take any any mediator from the street who has no feeling and no background in ISDS to do a proper mediation, I think.
So in principle, yes, but there has to be a good framework for it. And I really think it's important to emphasize what you mentioned about the trust. So if there's a healthy framework in the country and the investor knows that the mediation will be in good faith and this it's worth pursuing, then, so it's a larger project than just having an ISDS clause that mandates mediation. And there's also the broader discussion about the tension in the term of mandatory mediation. How do you approach it as mandatory if you're trying to come up with a common solution? But that's a whole different webinar, I believe. All right, we have a couple more minutes. I hope you will be patient enough because it's a very good question from Samira Suleimanovic, our previous guest. So thank you, Samira. It's about CETA. It says that CETA investment chapter is not enforced, but yet both sides, EU and Canada, frequently present solutions therein as model solution, even though they haven't been tested in practice. So how would you comment on this to conclude today's discussion?
Well, I think Samir is posing a very nice rhetorical question here. I don't know. Nobody knows. That's a purely fictional question and answer. I don't know. I mean, you can point, as I said, you can point to the WTO. Well, the WTO is in a deep crisis. It's actually the appellate body is in paralysis for the reason that insufficient appellate body members have been reappointed. So there is this question, but they have dealt with that because the idea is now that you would not have judges in the MIG being reappointed, so they would have only one non-renewable term. But in any event, we don't know. I mean, again, it depends very much. I think it depends very much on the perception, in this case, by the investors, whether this is going to be a fair court or a pro-state biased court. I think that's number one. Number two is these deadlines that they've taken. I'm not so sure that they are realistic, considering the sometimes complex, very complex facts and legal questions that have to be settled. And in this regard, I find it also very strange that, unlike the WTO, the EU is proposing a full de novo review at the appeal level. So meaning the review of the facts and the law. And I think that adds just so much more time and money because you essentially you get a second bite of the apple, right? A full second bite of the apple. And I'm not sure if this is a good idea. Yeah, I mean, we don't know. At the same time, back in the 1990s when the appellate body was created, nobody knew that either. And within a very short time, let's say from 95 until the 2000s, it did establish itself as an authority with very authoritative rulings, panel reports, appellate body reports, sometimes actually a bit too long, going into the 500 and 600 pages where somebody has to say, well, stop. But in any event, so probably you have to give the benefit of the doubt. But at the same time, and I think this is really an important question, is do you really want to break something if it ain't be broken? And I think that is a question that is not actually asked in the working group and is not answered. You are invited to pay and to create a system where you really don't know what the outcome will be. And just to be sure, according to the UNCTAD statistics, states still win more cases than investors, right? It's something like 33, 34 versus 28. And don't forget the 1/3 of cases that is settled, actually, without mediation, just settled for whatever reasons, right? So I think at the end of the day, the states have not been doing so badly under the current system. And that is something you really want to kind of reflect upon Is it really worth it to throw away something that, is working pretty okay? And we are reforming it quite a lot. There are new exit rules coming. As I said, there will be this code of conduct for arbitrators. It will come very soon. Probably there will be stricter rules for third-party funders, etc., and also with regard to double hatting and stuff. So I'm not so sure if it is all needed. But on the other hand, yeah, we don't know.
Yes, I mean, this would open another door for our next hour of discussion. So I would like to conclude there. But absolutely, there's so many things that could be addressed that are not being touched, and there are open questions about, is this going to be a wasted opportunity? Having this platform, having this forum to discuss actual improvements of the current system, is the discussion about just getting rid of it actually a waste of an opportunity to fix and make it more effective and, in accordance with the policies of the member states? Thank you very much for your time today, for this fascinating discussion. I have personally benefited very much from your insights, and I'm sure our participants have as well. Thank you to our guests today also in the audience. Thank you for your questions and for your attention. We will put the recording of this webinar as well as the others on the YouTube channel of Association Arbitry, where you can revisit the discussion as many times as you wish. And we will definitely like to welcome you back in a couple of weeks. We will be skipping the next couple of weeks because of Vismut activities and different a cluster of conferences that are coming up in person. But we'll be very much looking forward to seeing you again in the weeks to come. So follow us and stay tuned. Have a great weekend, everybody.